Welcome. My name is Donna Shioya, and I'm the founder of LifePath Law APC. So today I'm going to be going over a PowerPoint presentation that I've made, and we're just going to be going over the basics of estate planning. So I like to call that Estate Planning 101. Great. So the definition of estate planning that we're using is to control my property while I'm alive and well, to plan for myself and my loved ones if I become disabled or mentally incapacitated, to be able to give what I have to whom I want, when I want, the way that I want, so who gets my stuff when I'm gone, all while transferring my legacy along with my wealth. I like to use the analogy of a box when we're creating a trust. So I like to say that your trust is like an empty open box with instructions inside which fit your goals and needs at that time. Okay? Those instructions, however, of that in that box or in the trust only apply to assets that you have transferred or that you have put into the box or trusts or assets rather that you have transferred to the trust. So while you're alive and well, that box is open. You can put assets in, you can take assets out. Okay. So from the time that you create that box, when you're sitting in the estate planning attorney's office, until the time that you need it during your mental incapacity and or passing, that's going to be a lot of years in between are going to pass. And during that time, your instructions should really change with changes in your life, changes in your finances, and changes in the law. So changes in your life, I think, are pretty self-explanatory. Perhaps you've decided you want to change who the trustee is. You want to change the person who's on your disability panel. I don't know, maybe it was a friend that you were good friends with, but years have passed and you're not quite as close anymore. And perhaps you'd like to name somebody else. Guardians of minor children or something that is commonly changed as well. Changes in your finances, whether that's you're acquiring new assets, closing down old assets, and maybe just the amounts, if the amounts have changed there. The changes in the law. So when a trust is administered, it's administered in light of three things: what we write into the trust, what federal and state statutes are in existence at the time that we are administering the trust, during your disability or at death. Okay. And then also whatever case law is in existence at that time. So statutes are actually passed by the legislature. Case law, however, is made when people, maybe let's say that there is a trust and there's a dispute over the terms of the trust, and given the facts, somebody is fighting, somebody thinks that they should have gotten something when they didn't. Perhaps there's a change in the law or the way that things are being interpreted. So what will happen is a case is brought. Perhaps there isn't an answer yet for that, or so what the judge will do at that point, what the court will do is that they will take a look at the law, they will take a look at the fact, and then they will say, well, this is how we interpret the law. And so this is a really new law. It's called case law. So case law, how often is it made? It really depends upon how many lawsuits are being brought at any given time. So just from the time that I started my practice, which was back in 2007, I would say the number of appellate cases that were coming out during that time were probably per year, maybe 4 cases a year, 4 to 6 maybe cases a year. Fast forward to 2025. Sometimes in just a 1 or 2 month period, there can be 4 to 6 cases that are coming down within even a 1 to 2 month period. I've seen that before. So what's happening here is not really magic. It's just math. We've got the baby boomer population, which is right now, I believe the beginning ages of the baby boomer population is about 79 years old. That's 61 million Americans are 79 years old. And I think the baby boomer population is about a 10 to 13 year time span. But this 61 million or 61.5 million Americans are aging. And so we are seeing just a large number of people that are either having to deal with incapacity issues through Alzheimer's or dementia, or people passing away. So what is happening is we're just seeing larger numbers of people that are dealing with the biggest transference of wealth that this country has ever seen. So a lot to fight about, unfortunately, but that's how case law is made. And that's why we are seeing an increase in the number of cases that are coming down as the years progress. I just anticipate it becoming more. That we're just going to have much more case law. In addition to doing estate planning, another part of our practice, we do uncontested or straightforward trust administrations where everybody's getting along. There's no fighting. But another part of my personal background, I started off as a litigator. So I've always drafted my trusts very differently in the sense that defensively, I guess I would say, is that I have been practicing exclusively in trust in estate litigation, estate planning, and uncontested matters since I started my practice in 2007. So we have seen an increase of cases being brought to bear. And as those cases and new holdings come down, we then will review our trusts and our other estate planning documents once a year and update those documents for changes in the law. And that's going to be important because there are a couple of things we don't know. We don't know when you're going to pass, and we don't know what laws are going to be in existence at that time. Okay, so part of our this second phase of the estate planning process, we do also offer a formal update and maintenance program, which I will talk about later in the presentation. It's not mandatory to participate, but that is a service that we offer, and I think you'll see the benefit later here. So um, just to recap, from the time that you create the trust until the time that you need it during your disability or at death, many years will pass typically. And so through the maintenance program, we're able to help update your estate plan for changes in your life, changes in your finances, and changes in the law. So once you pass away, the box closes, okay? The trust becomes irrevocable. No more changes to your assets or instructions can be made at that point, and the person that you've named as your trustee will then open the box, follow your instructions, and distribute the assets that you've placed into the box according to your instructions there. Okay, so just to review here, we've got empty open box, instructions in there that fit your goals and needs at the time. Those instructions only apply to assets that you have properly funded to the trust. So you've put those assets into the box. During your lifetime, that box is open. You can add new assets. You can take assets out. We are updating it. If you're participating in the maintenance program, you're going to be updating it for changes in your personal circumstances, your finances, and the law. And then once you die, that box closes. No more changes can be made. You can't really add assets afterwards. Technically, you can, but it does involve having to go to court for that. But then the trustee will open the box and administer your assets per the terms of your trust. So what are the basic benefits of a trust? The basic benefits is that it avoids probate. And I put that in quotes because a lot of people will say, I just want to get a trust because it avoids probate. I'm not really sure what that is. I just know it's bad and I don't want to do it. And doesn't the state take my money for that? So let's kind of back up a couple of steps. Probate is the process if you die without an estate plan in place. Okay, without a trust-based estate plan, you can also have a will-based estate plan. However, a will-based estate plan, if you choose only to have a will instead of a trust and a will, which I will talk to you about later, a will is basically a letter to the judge. So you will be going through probate court to have a probate. Okay. So most people like to get a trust because it avoids probate. That's kind of the very simplistic answer. And the caveat to that is A properly a properly executed and funded trust will avoid probate. Yes. Okay. The second basic benefit that used to be touted for having a trust is that it can double the amount that passes tax-free to your beneficiaries. This was for married couples. Trusts were basically came to be as a vehicle to allow spouses to be taking advantage of. They each would get a federal estate tax exemption, and to be able to double that amount. For married couples. The reason why it's crossed out is that you no longer need to actually have a trust split into two upon the death of the first spouse. In order to take advantage of this, you now actually you just have to file the proper forms with the IRS within 9 months of the death of the first spouse. So it's not necessary to split the trust into two. Upon the death of the first spouse. That being said, the federal estate tax exemption currently is over $13 million per person, meaning that anybody can die and leave $13 million to anybody they'd like with no estate taxes. And then anything over that would be taxed at about 40%. So most people, they just slide right in there and qualify under that federal estate tax exemption. All right. The personalized benefits of a trust. So the question is, okay, it avoids probate. What's so bad about probate? We'll talk a little bit more about those fees later. They're very, very high. But if we don't need a trust, then if all I have to do is file a form with the IRS, then why am I getting a trust? Well, the personalized benefits of a trust is that you can plan for yourself and your family in case of your mental incapacity. So if any of you watching are single, I think that this is a very, very important part of planning, in that typically for married couples, they have their spouse who's going to be that partner who's going to naturally be the person kind of caring for the other spouse, in the case of a mental incapacity. For those that are single, you don't necessarily have somebody who is assigned, and you really need to put things in place to make sure that a person that you pick is in charge of your assets, to use your assets for your care the way that you want during your mental incapacity, whether that's Alzheimer's, stroke, dementia, or whatnot. Okay. And the other personalized benefits is you can build in protections for your surviving spouse and your beneficiaries after your passing. So we'll talk about those protections in a bit. Let's go over what a trust does not do. It does not protect your assets from your creditors while you're alive. Okay. It does not hide your assets from the government, and it does not allow you to avoid paying taxes while you are alive. If you've heard of anything like this, a trust like this, give me a call. I'd like to find out about it. Many times, unfortunately, there are scams out there, and just do your research. Feel free to give our office a call if you've got questions about that. But these things, a trust, a revocable living trust, does not do any of these things. Okay. What is probate? Okay, it's the core process to deal with your assets. As I've mentioned before, if you've done no planning, if you have a will, so you decide you want to do a will-based estate plan, a will is a letter to the judge saying, "Dear judge, when I die, I want you to take everything through the probate process through court, and then I want you to make sure that my wishes are administered per this letter that I'm writing to you." Okay. Probate is also a process. You end up there if you have a trust, but you didn't put your assets into the trust. That's why the box is empty right here in this circumstance. It had been closed, but then when your trustee went to open it because you hadn't put the assets in the box during your lifetime, meaning you had not funded the trust, there's nothing in there. Okay. So why do we want to avoid probate? It's very, very expensive. The probate fees for attorney's fees and for executors or administrator fees are all set by statute. And I think they say a rule of thumb is that the cost is up to 5% of the gross estate of the assets in probate. So let's say if you have a house that's worth $1 million, okay? As of date of death, it's worth fair market value, $1 million. Then the fees, the statutory fees for that are going to be about $50,000. Okay. And that's a fee that goes to the attorneys and to the administrator, the person that is appointed to actually marshal the assets and to distribute them. A better one that I know a little bit off the top of my head better is, let's say your house is worth fair market value at $500,000 as of date of death. And you say, well, hold on, I've got a mortgage of $480,000. I only have $20,000 equity. It does not matter. The fees for both attorney's fees and the administrator fees are determined based on the gross fair market value of the asset of the probate estate as of your date of death. So in that circumstance, you have $20,000 equity, but a $500,000 fair market value. Probate estate is going to result in $13,000 in attorney's fees and $13,000 in administrative fees. So that's $26,000 to probate or to transfer an asset in which you only have $20,000 equity. So it takes very long and it's a totally public process because the probate courts, I'm not sure what's going on, but it seems like there is a little bit of a disconnect because the probate courts seem to be cutting down on staff and availability. And right at the time that just demographically the population is aging and we really are needing those resources more because of that it can take months and months to even get somebody appointed to get the power to marshal the assets in your estate to administer them. Okay. So here at LifePath Law, we follow what's called the three-step strategy. We develop your personalized plan and we partner with you to update your changes regularly to maximize the wealth that you pass on or that you transfer to your loved ones. Okay. So there can be a range of estate plans from off the shelf or actually now, whether that's, I think it used to be called LegalZoom or AI, just whatever is out there, programs off the shelf for Home Depot. I think you can go from that end to something that's more personalized when you're working with an estate planning firm. So we say counseling at no additional cost in our three-step strategy. With this, and we will talk about costs, or your estate planning attorney will talk to you more specifically about our fee structure during your initial interview. We build in a very, very generous amount of time in our flat rates and only in circumstances where maybe perhaps we've got some pretty complicated family issues. A lot of times it's blended families, or if we were dealing with inheritance from other families, from other family members that have come in, or perhaps we've got different business interests. But those are more the rare types of cases. I would say most cases that we have, we are able to fit within our flat rate.